you mind if we start with a prayer, David?
Sure, go ahead, Julian. Definitely.
All right. Thank you so much, Almighty Lord God, for just bringing together this wonderful group of students. Thank you, Lord, for the opportunity to speak of the remedy that you have hidden for us in chancery courts. Lord, the opportunity to just come in peace and honor and to be able to exit Babylon and be left alone by the Babylonian authorities there, Lord. We thank you so much for speaking through us, for preserving this remedy for us, for calling out your people as separate from the world, to be a bastion of truth and freedom that others can look to for help in their time of need, their hour of trouble. Lord, I just ask you to guide everyone here that is in need of your helping hand, to be open and receive the remedy that you have preserved through us. So I thank you so much, Lord. I ask that you guide us and use us and speak through us. In Jesus' name, amen. All right. So, hang on.
You may need to reshare your screen if you're going to do the presentation. It may need to select that screen view. Okay, I think it's working now.
Is that all right?
It says video is paused.
Okay, I tried to go into full screen there, but it looks like
I can see it. I can see it here.
Can you see when I switch slides like this?
Yes.
Okay, cool. Thank you. All right, so we teach equity, really a form of it called post-1933 equity that's been updated to the modern day. We're going to learn all about the concepts of honor and dishonor and just what equity can do for us. Our new class is going to be starting in February, mid-February. So today we're just going to cover some of the basics of equity, what it means to go toe-to-toe with a judge. We're going to touch on legal entities like trusts, PMAs, and ministries. And of course, we're going to give you some testimonials. So equity is the law of just and fair dealing, which seeks a more adequate remedy than that which is available in the strict common law. And it actually came about because the common law was so strict that it did not have any remedy for the rights of a beneficiary. When trusts first came about, the common law just saw the trustee as owning everything. He could just abscond with all the land and the money. You know, if somebody went off to war and they left their land and their money in the care of a trustee for their family, you know, if the person was more unscrupulous, then the family would just be out of luck. There was no court that could even give them remedy. And all throughout the centuries, you can only get remedy in common law if, you know, your cause of action fits into a very specific box. And then even if it does, the remedy that's available to you might not be what you need. So equity has the power to not just compel somebody to pay you damages, but actually to compel specific performance on their part. And that's really what equity is all about. It seeks the perfect remedy for the situation. And if no remedy exists in precedence for a situation, equity will actually invent a new remedy in order to give the most ethical solution to the problem. So this is what makes equity the highest jurisdiction, and this is why it's been established in maxims of law as the highest jurisdiction, is because there is no higher way to strive for what is most ethical, and that's really what the law is all about, is doing what is right. Obviously, it's gotten very far away from that in the modern day, but that is the basis of it. So this is a quote from John Bouvier, and a lot of you, I'm sure, have his dictionary sitting on your desktop somewhere. Law is nothing without equity, and equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have a weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted, or those whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Positive law is construed, and rational law is made by it. So the modern uses of equity was very much, just like everything was, very much affected by the banking crisis of 1933. And, it happened March the 9th, 1933 in the U.S., but every country in the Western world, whether you're from Canada or Australia or New Zealand or wherever, and we have students from all of these places and more, all these countries are bankrupt. And all of these countries have moved away from gold and silver backed currency into just free-form negotiable instrument money that isn't even really money. So at least in the U.S., in 1933, that was the year that they took our constitutional money away from us, the gold and silver. They would have been traitors to the Constitution, except that they gave us another remedy. They just didn't tell us what it was it took us 90 years to figure it out. So with equity, we can access that remedy. The Rules Enabling Act of 1934 gave us the Federal Rules of Civil and Criminal Procedure, and commercial law, common law, and equity were merged under one court system. But equity is still available to us. We just have to be the ones to bring it. They're not going to tell us about it. Certainly an attorney is not going to tell us. But we can compel any judge in the Western world to put on his chancellor's hat, so to speak. We just have to be the ones to bring it. Very important is the supremacy of contracts, and we're quoting from the Constitution here, but again, this is, every Western country is participating in the same commerce. The world system wouldn't work the way it does unless contracts were supreme in every country in the Western world, and we can search this out in the Canadian Constitution or the Australian one or anywhere else. It's always going to be the same. So Article 1, Section 10, Clause 1 of the Constitution says that no state shall pass any law impairing the obligation of contracts. And I know that's a lot of ellipses in there. Just trust me, that phrase is not affected at all by what's shortened by those ellipses. You can look it up yourself. But this supreme clause basically limits the rest of the Constitution from that point forward. So you are able to contract away your unalienable rights. That is the power of contracts. And unfortunately, most of us have done that. Unless you have, no birth certificate, no social security number, no driver's license, no voter's registration, no selective service, no bank account, you have contracted away most of your unalienable rights. And in equity, there's a couple of different options. We don't mind being in that position in equity because we know how to discharge any debt or charge brought against us in that capacity, as a so-called 14th Amendment citizen, or as a surety for a stranger, as the Bible would put it. You can also use equity to unmake those contracts, and we're going to talk about the equitable remedy of rescission as well. So really, all the options are available to you. So why stay in equity? Well, in equity, there are maxims which state that the position of the defendant is preferred. And if that sounds strange to you, well, it certainly goes against everything we've been taught, right? Why would you want to be taken to court? Why would you want to be sued? Well, of course, if we can avoid these things, it'd be better. But in equity, the position of the defendant is preferred because we can discharge anything brought against us in that capacity. It's a very powerful maxim. And if you haven't been getting preferential treatment as a defendant when you go to court or with a bank or whoever, then maybe it's time that you tried something new. Equity also has the power to unmake any contract, another reason why the position of the defendant is preferred. And the remedy there is called rescission. Rescission is not available to you in any other process except in very limited conditions. There is such a thing as commercial rescission, but it's only available within 72 hours of you signing something. Beyond that, you have to actually ask a court to allow you to rescind something. Of course, they're not going to let you do that. So, but there's no time limit on it in equity. Equitable rescission is available to you at any time. There's certain conditions that need to be met, but they are highly subjective if you know how to use them. So who can bring equity? Well, first of all, equity requires no particular status. You can begin learning equity right now. You can assert a proper identity immediately without having to file a bunch of status correction stuff with the U.S. corporation. If you want to do status correction, that's fine. It's just that I'm just saying you don't need it for equity. The term attorney at law is something we've seen everywhere. We actually see it on billboards and plastered all over the cities when an attorney puts up an ad. If you look in Black's Law Dictionary, if you look under the definitions of at, there's many of them, but one of them is near. So we like to say that these are attorneys near the law. They are operating in a fiat fake jurisdiction whose laws are voluntary, whereas we are in law. We are in the law. Judges fully recognize equity when we stay in law. We don't do at-law things like filing things and arguing and challenging jurisdiction, and hiring attorneys, and a long list of adhesion contracts that we know how to avoid. Attorneys can't do this for you. Maximum of equity states that equity acts in personam, which means it acts on actual beings, not on legal fictions. So attorneys can only represent legal fictions, so they aren't even allowed to bring equity. In equity, we teach the art of inquiry. By asking questions, we get facts onto the record without testifying. This allows us to stay in honor and avoid contracting with the court. Why? Because when you testify and make claims, you're going to have to prove them. If you avoid testifying, you're not creating controversy. The duty of a court is to eliminate controversy. So in our class, we teach the art of inquiry. We have a very, very powerful court script. But beyond that, a judge is always going to go off script. You're going to have to know how to improvise. And we teach you through role play and through numerous examples how to go off script and still be able to come up with that powerful, equitable question when the judge asks you something that you weren't expecting. Equity is all about coming in peace and staying in honor. So we don't argue the facts, jurisdiction, law, or venue. We do not file. We do not testify. We just ask questions. We compel performance, and we use the law of notice. And our questions are far more powerful than any argument or anything that you could file into any court anyway. So ever since the banking emergency, there's no lawful money in circulation. If you look at a Federal Reserve note, well, it has the word note right on there. If you look up note in Black's Law Dictionary, it's just evidence of a debt. You can't pay a debt with a debt. In fact, just using Federal Reserve notes in some ways is an adhesion contract in and of itself, because they're giving us the benefit of not even having to pay our debts. At least that's the way they see it. That's a whole nother rabbit hole, but there is no lawful money in circulation, so we cannot lawfully pay for anything. So how do we settle the charges against us? Well, with equity, we can discharge any charge according to the remedy that was established in 1933, which is debts are discharged dollar for dollar, and that negotiable instruments pass freely as a substitute for money. So any debt, any criminal charge, any warrant, any court order, citation, etc., excuse me, can be discharged lawfully and honorably. Thank you, Ellie. So how do we do that? Well, when you are given something with your name on it, say a summons or even a warrant, typically you're not given the warrant, but you can get your hands on it. You have a liability and a power. So we have the liability to reply, and our reply has the power to create discharge. If you look up the definition of discharge under the subheader of equity practice in Black's Law Dictionary, it says, in the process of accounting before a master in chancery, and a master in chancery is basically anyone who can take an oath. It could be the janitor of the courthouse for all we care, but obviously that pertains to the judge. In the practice of accounting before a master in chancery, the discharge is a statement of expenses and counterclaims brought in and filed by way of set-off by the accounting defendant, that's you, which follows the charge in order. Well, of course it follows the charge. You gotta have a charge to have discharge. So it's all about accounting. Counterclaim and set-off are accounting terms there, but they basically speak to how we are paying for things when we can't really pay for anything. But it says right there, equity makes you the accounting defendant. So whether it's criminal or civil, equity just comes in and says, okay, let's just treat everything like a line item on an account. We're just going to settle the books. We're not here to argue about the actual facts of the case. We're just going to help you settle your books so that you can get paid and we can go home. And it's worked for us hundreds of times at this point. And you have to stay in honor in order to bring equity. And so this is what it means to come with clean hands. There's two positions in law. We're going to talk about coming with clean hands in a minute, but the two positions in law are honor and dishonor. We see people prosecuted oftentimes, several people a week at the least come to us with a case that they would like us to look at, to take on. We've been doing this for about a year and a half, and we've seen a lot. So basically, oftentimes we see people prosecuted more for the commercial dishonors that they have committed than the actual charges that have been brought against them. Mm-hmm. And when I'm talking about honor and dishonor here, I'm talking about commercial honor and dishonor. I'm not talking about ethical honor and dishonor. Commercial honor and dishonor is a totally different concept. And really what this originates from is old maritime law. If you say you're sending a crew halfway around the world and they need to go to a certain port, and 6 months from now there needs to be provision for them so that they can make it back and not be stranded or some other terrible thing. So you need this much rope, you need this many biscuits and butters, and it's got to be available for them at this day at this port. And you didn't have time to send back and forth. Well, I don't like this price. Let me send this back to you, because it takes months to send these things around the world. And they just didn't have time. It took months from the sale there. It wasn't going to work if you had to argue back and forth with somebody about prices. So it became honorable. This system of honor arose to accept what is presented to you on its face without arguing about it, without stipulating about it. And this goes on to the modern day. Anything that's placed before us, we have a duty to honor it. So we teach you how to do that in a way that does not consent to the things that, these things are accusing you of, these papers they send you. We don't consent to any of it. We just honor it. I think we got somebody with an open mic, David, if you wouldn't mind muting them.
Yeah, everybody, if you could please stay on mute. We are going to do the Q&A later, but everybody please stay on mute in the meantime. Thank you.
So how do we stay in honor and discharge any charges against us without arguing or testifying or filing anything? Well, after 1933, all laws governing all commercial matters were updated to include the term payment or performance, or payment or acceptance. So the Emergency Banking and Relief Act of 1933 is HJR 192. Well, as most people know, HJR 192 was repealed at a certain point. However, it was still codified into public law before it was repealed as Public Law 7310. Public law is higher than a House Joint Resolution anyway. So, and even if it wasn't public law, all the laws were changed to say payment or performance in as set forth in HJR 192. So the idea of HJR 192 being repealed really has no bearing on anything. When our name is on something, we have a liability to honor it. And you're going to learn how to properly accept presentments. It's not about just writing accepted for value on it, okay? Accepted for value is just a made-up phrase from the Patriot world. I mean, you're not going to find the term accepted for value in any law book, in any act of Congress, anywhere in the world. You'll find the term accepted, and you'll find the term value, but you're never going to see them put together. It's just a made-up phrase. And then some people use accepted for honor. Accepted for honor does come from the Bills of Exchange Act, but it's a very particular situation that really has nothing to do with anything that we need to do. So I'm not really sure why people use that. And then there's some other ways that people do it out there, but I haven't seen anybody doing it the proper way that a bank would do it with another bank, which is because we teach that particular method. I believe that's one reason why we see so many successes from it, because we're just doing it the way a bank would do it. So we're going to teach you how the proper way to do that in the class. So let's talk about some maxims of equity. Equity seeks to prevent the wrong itself. Well, doesn't seek to just give damages, right? You can actually compel specific performance to have the most ethical outcome done. So they have to actually drop the case against you if you're going to bring honor and properly bring equity. They don't just, do something bad to you and then award you damages later. Now, there is also the equitable remedy of redemption. If you had something seized from you against your will, then equity can come and award you the value of that thing. And we've seen that happen before as well. We actually had a case where a court had issued an order to garnish someone's wages down in Louisiana. And that's good news for those of you in Quebec, because they're both under Napoleonic law. And we brought equity to the case, and they actually, not only did they discharge the wage garnishment, they actually sent him back all the money that they had taken out of his checks. So this is the power of equity. It seeks to prevent the wrong itself, not just, provide you hyper-specific remedies that may not even be what you need, like the common law does. He who seeks equity must do equity. Well, this is very similar to he who comes into equity must come with clean hands. I mean, you have to be in honor. You have to have a heart of forgiveness. You can't be trying to persecute and get vengeance and justify that. You simply need to come in equity. You need to come with an honorable heart. Equity will not suffer a wrong without a remedy. This goes back to the idea that where no remedy exists, equity will make up one just to suit the most ethical outcome. If you have been wronged, then equity has a remedy for you. Equity aids the vigilant and not those who slumber on their rights. Well, this just speaks to the idea that the sooner you act, the better, the smoother things go. The strict application of this has more to do with trust law. However, it does make things smoother to act more quickly, but you'll see in the class that there's a certain way that we do our notices that actually makes them constructive in the sense that they can essentially time travel. So even if you have had something sitting on your desk for 20 years, now that you've learned equity, well, you can treat it as if it just came in the mail yesterday. So you didn't know about your rights until you learned how to exercise them, and now you're not going to slumber on them. Equity regards that as done, which ought to be done, and what ought to have been done. Kind of the same thing. Equity seeks to prevent the wrong itself. It's going to go back and help you correct mistakes that were made. As I said, it can time travel. Even if you've already been through a whole case, you've already been judged, maybe even were penalized and sentenced, you can actually go back and clean your record and correct the mistakes that you committed on that case, the commercial dishonors or whatever process that you used. You can go back and correct things. Then equity will not aid a volunteer. The term volunteer here actually relates to contract law. A volunteer is somebody who enters into a contract without receiving the benefit. It's like a beneficiary, really, of a trust, because it's somebody who enters into a contract without giving consideration. So in the case of a beneficiary, he's not giving anything to receive, he just gets stuff. This really pertains more to trust law. We do like to say, though, that we shouldn't go volunteering for their contracts. We shouldn't go just walking into the rake every chance we get. You got to learn what their adhesion contracts are so that you can avoid volunteering to come under their laws. Because as we know, the U.S. corporation has set up things to be like a trust. So it very much pertains to the modern day. It's just that the application has been a bit hidden from us. But essentially, we don't want to be volunteering for their contracts. So anybody can just give you some paperwork and say, oh, they're not going to want to mess with you after this affidavit. This affidavit's so powerful, they're just going to leave it alone. And just send all this into the court. They're not going to want to mess with you. And we see this stuff all the time. It almost never works. Everything out there works occasionally. You can have the worst process out there. It's still going to work like 1 in 1,000. But what kind of teacher would I be if I just gave you a bunch of paperwork and said, oh, you'll be fine, don't worry about it. So we actually prepare you how to defend that paperwork in a court before a competent judge who's trying to trip you up, who's trying to recontract with you. And this is one of the major things that sets our class apart. We just extensively prepare you for court. It's very important to go to court if you are summons to court. I mean, if you don't want to go to court, this is how you get bench warrants put out for your arrest. So we stay in honor by going to the place of judgment. The court is the bank, and the judge is the banker. So, of course, he's the one who can discharge the charges. We want him to have jurisdiction. Why would we not want the banker to have jurisdiction? I mean, that's how we get things discharged. So I think there's somebody outside the door, honey. Could you check on that, please? So stay in honor, go to the place of judgment. We have the best court script available. You're not going to find any greater courtroom prep. And we go to great lengths to prepare all our students to have a dialogue with the judge as standing equal with the judge, because equity makes you equal with the judge. Well, the judge is known as the law speaking. So in that sense, equity makes you equal with the law. And we're even going to do role play sessions and hold mock court sessions to ensure that you're getting it. And then we prepare you for the judge's mind games. I mean, they have all sorts of ways. They try to play dumb. They try to pretend like they're really angry at you. So we study courtroom psychology and just give you that upper hand in order to understand what they're going to be throwing at you. And we have a lot of experiences in court, and we can just run you through the whole gamut of what the judge can say, what the judge is gonna be trying to do to you. We just take a deep dive on all that behavioral psychology stuff with the judge. I just wanted to mention this. I mean, it's a separate class from equity. We have a trust class that has been over a year in development. The equity class is a prerequisite for this because there's so many tax things to do with trusts, and really there's no better remedy for taxes than equity. I mean, it's just the IRS is actually one of the easiest agencies to deal with. They readily accept equity and understand it, and it's actually one of the safest things to bring equity to. I know that probably sounds very surprising for many of you, but we've discharged probably more IRS debts than anything else. And that's because it's easier for the students because they don't even have to go to court with the IRS. That's how readily the IRS accepts equity. And the CRA is the same way. The Australian tax office is the same way as well. So anyway, the equity class is a prerequisite for the trust class because so much of trust is about, decreasing your tax burden. And it's just all this human effort is expended on how to decrease your tax burden and jump through these crazy loopholes that have been invented for tax purposes. We don't need to worry about any of that with equity. I mean, if you are properly trained in equity, you could just skip all that and it's going to save you a real headache. So that's why we make it a prerequisite. But I just wanted to touch on this briefly. This trust class has been over a year in development. It is much different from anything else that you've heard out there. Most people setting up trusts, they're going to tell you one of three things. They're going to say, okay, you have to give everything over to the trustee, your whole business, your whole life, everything, and you better really trust that person because they're in charge of everything. You can't touch it. Well, that's lawful, but it's not very useful. It's practically useless. I mean, who knows a trustee like that? They're just going to give their entire lives over and just, maybe some of you have somebody like that in your lives. It's awesome. But, don't you want to be controlling your own business instead of just giving the whole thing over to somebody? So not very useful. The number two would be these people that tell you, oh, you can be the trustee and you just get all the benefits, but you pretend like, that somebody else is the beneficiary, even though you're the trustee and you're living on the property and you're benefiting from everything. Make your dog the beneficiary and you just take everything. And then you're the grantor too in some way. And it may work well enough to like get stuff transferred and just day to day, but if any court ever looked at that with just the slightest amount of scrutiny, it's going to fall apart instantly because you're wearing multiple hats in the trust. Where's the trust? I know a lot of people teach to set up trust like that. It's just, it is so far from best practices. I don't even know why that's so popular. I mean, it's just going to fall apart the second a judge even looks at it funny. And then the third way people teach to set up trust is just a statutory trust. I mean, you can go to any attorney and get a trust set up, but it's going to be highly pierceable by a court. It's not going to fall apart as quickly as the second one, but it's going to, fall apart under scrutiny anyway. So what we do is different from all of that. We have found a completely lawful way to get your name off of everything, own nothing and control everything, as Rockefeller said. And that's the real spirit of what he said. None of the three trusts that I mentioned previously are going to be what Rockefellers are using, okay? They're not going to just give everything to somebody. They're not going to do things that are obviously going to get them in trouble. And they're not going to use a statutory trust either because they don't want the courts to have any say over what they're doing. So we have found a structure that allows you to truly own nothing and control everything. And it's very complex. You're using multiple trusts and multiple entities, and they have interlocking responsibilities in order to insulate you from liability. But there's no better method out there. And, it may take a little bit more work when it's that complex, but we're going to teach you how to do it. So anyway, that's a separate class. I just wanted to let you all know about that. So back to equity. Well, equity can give us freedom without having to memorize case law, rules of procedure, endless statutes and regulations. You guys can leave all that for the attorneys. Equity is above their commercial realm, their fiat fiction matrix. And you can choose to drop the arguing, drop the fighting, drop the challenging of jurisdiction. Just come in, ask questions, help them settle their books, because there's no more money anymore anyway. It's all, performance and signatures, and just be left the heck alone. I mean, you don't have to go to court to argue with the judge. Everybody knows the system is broken. They know it. You know it. You don't have to, you don't have to argue that with them. Just do what needs to be done. Be left the heck alone. The entire matrix, or whatever you want to call it, is run on the principle of secrets and fictions and voluntary laws. They have secret trusts, secret statutes, secret definitions of language is the major one. Court is all about secret contracts with secret terms, and then they penalize you for violating these terms that they didn't even tell you about. On the other hand, remedy is based on exposing the matrix presumptions in one form or another. And we do this with equitable questions and with our notices. We compel the performance that we want to see happen by pricking the conscience and implying or exposing their liability. We use their own laws against them, essentially. The matrix presumes, well, you are this fictional entity. And remedy questions, is that so? And comes with the questions that compel them to leave us alone by exposing their secrets and adhering to their laws of honor. Equity is based on God's word. It allows for the court of Babylon to become a court of conscience where miracles can and do happen. We have seen many miracles in equity. We come, we stay, and we leave in honor. It's very, very important. We use their own laws and commercial procedures. We don't testify. And I say we use commercial procedures, but we wrap them in a vehicle of equity. We can go a lot deeper on that. But we ask questions, and when we stay in equity, there is remedy 100% of the time. I have never seen this remedy fail when somebody internalized it, stuck to it, and didn't mix it with anything. And I've never seen any other process even come anywhere close to being able to offer something like that. So these are all the places that we know of that equity has succeeded so far, the specific equity that we teach. United States, Canada, the UK, Ireland, Australia, New Zealand, and even France. So we have seen equity work. And we even have a student in South Africa now that's applying equity to her case. So let's talk about some testimonials. And yeah, after we get through these, I'll be happy to take questions. And yeah, if any of you that are just now joining or who joined late, I'm going to show my screen name in a few moments. You can contact me on Telegram. I'd be happy to show you another introductory video, somewhat similar to this one. And then there's some class information I can give you. It'd just be through Telegram that happens. And you can either right-click on my name and click on send message, or I'm going to put my actual username on the screen in a few minutes. So let's look at some testimonials. First of all, is just things that my wife and I have been able to apply equity to in our lives. And you know, we discharged a credit card before it ever went to court. We discharged another credit card post-judgment. We discharged my wife's IRS debts. We received actually multiple letters from the IRS stating no further action is needed on your account. We used our family Bible for a name change in Chancery Court without having to show ID and all that kind of stuff. Or a marriage certificate or any of that, because we have a marriage under God, not licensed by the state. Back before I was doing this full time, I had a job in architecture and engineering, and I got my job to cease taking out all the fruits of my labor and stop withholdings. And there's a way that we teach you how to do that in the equity class. We can teach you how to do that without sounding like a sovereign citizen or something. We can teach you how to just have a very professional conversation with them, and give them something that will help them understand that they are avoiding liability and giving you what you want.
Immediately.
It's like giving yourself a raise. We used equitable questions to compel our landlord to hold to a rent amount that was previously promised, and there's been no increase since 2021. And we've gotten out of at least 4 speeding tickets using a script that we provide in the class. Our traffic stop script is amazing. The one that we give in the equity class, it has helped hundreds of students at this point to get out of speeding tickets and be either just let go or let go with a warning. And here's the testimonies. Just these aren't victories so much. We're going to get to those in a second. These are just about the power of the class, what it does for people, how it helps them act in greater confidence, and just the power of the teaching. So Anna Maria says, I am learning from the class that we should not mix processes. We don't get out of anything. We fulfill our obligations. And when she says that, there's a very particular way that we do it. We don't use the green stuff in your wallet. Let's put it that way. We begin to understand that we have the ability to discharge our obligations using equity. I am unlearning how I have been operating in the past. It becomes a new way of viewing the world around me. It's life-changing. Bruce says, wow, I'm shaking off the cobwebs, unlearning mixed processes, and I've seen many. Can barely express how much I appreciate Julian in bringing forward what I clearly recognize as a powerful way to competently operate one's stewardship interests, free from controversy. The tools, can't say enough about the tools provided. We are in the right place at the right moment. And when it comes to mixed processes, by the way, I mean, it's very important that equity not be mixed with anything else. Anything. It's a comprehensive process in and of itself. It doesn't need to be mixed with anything else, first of all. But second of all, when you begin to mix processes, there's going to be fundamental underlying concepts of law that are used in one process that totally contradict the fundamental underlying concepts of the other process that you think you should use. And when you do that, the judge is going to call you double-minded. And these people actually get ordered for psych evals by a court. This is the court's way of telling you, you're double-minded, cut it out. And in some ways, I mean, they're not entirely wrong to do that, because you're mixing concepts that don't even belong in the same bag.
Good to know. Yeah.
Chris says, very interesting work you guys have accomplished. You are definitely taking this equity thing to a whole new level. The Lord is awakening something new here. The subterranean movement to break free from this matrix system has been around a long time, though it's been mostly about the blind leading the blind to find the way out through fleshly legal theories and spiritual energies. But I see where the Lord is raising up people like you to become leaders in a true spirit-empowered end times Exodus movement, as we read about in Revelation 15, 2 through 4. It's powerful. And we have a thriving Telegram community, by the way. The alumni group has over 120 students in it at this point, with many more to come. And that's just from 4 classes so far that we've done. So we're about to start our 5th series. That's what we're hoping you'll all join us for in February. And once you're done with the 13-week course, you'll be moved into the alumni group. And the alumni group is like a whole other class in and of itself. I mean, there's people there applying equity to their lives. We research deeper into certain subjects in order to give people, more to stand on when they go to court. And I mean, it's incredibly powerful to see the students applying equity in their lives and sharing their experiences with each other. And I also put this in here just because it's so powerful what this can do for us spiritually as well. I mean, equity comes straight from God, and it's a lot more than just getting remedy in a court of law. The concepts of forgiveness and repentance, they are very, very powerful weapons that we have been given. They can take the dagger right out of the enemy's hand. And so this was written by a student whose husband was killed, was murdered by the hospital COVID protocols. She said, "Forgiveness was unthinkable to me because what they knowingly did was just too evil. But now I know what needs to be done, and it's exactly that, forgiveness." She found some notes concerning her husband's care in the hospital, some old notes that she had. She said, "Finding those notes feels almost like a spiritual presentment from God. I have the power and the liability to accept and return this opportunity by beginning the process of forgiveness in earnest. I believe that it's no accident that I was led to this beautiful concept of equity, its wise and genuine instructor, and its lovely group of fellow students at this particular time in my own life. I am truly grateful on so many levels." So it's just incredibly powerful, the transformation in people that we've seen. There's a lot of people that come in very, very angry, feeling like victims. And forgiveness is not because the other person was right. They're wrong. We get that. Okay. Forgiveness is so that you can be right. And when you operate from a place of forgiveness, you will see remedy. You will see miracles happen. It's a commandment from God for a reason. It undoes something in the spiritual realm that kept you bound, and it stops the spread of evil in society and in your own heart. So it's a very important concept, and this is why we don't argue and we don't fight. And we truly come with forgiveness. We don't argue. You will see remedy. Let's get on to some victories. So here's one of our students in Australia. Australia, for some reason, they're just crazy about traffic charges. They just love to ding people on traffic charges all day long. So this student of ours had like 4 tickets in a very short period of time when she found us. On all 4 cases, she received signed letters stating, quote, "Following a review of the above mentioned matter, I wish to advise you that no further police action will be taken against you." Imagine receiving a letter like that from the police.
No further police action?
Yeah.
She also had a $2,000 fine, by the way, that's been discharged as well. And here's from a woman who I studied alongside who was dealing with repeated threats from the IRS for tens of thousands of dollars worth of missed payments. She said, "Thank you. I just got a letter yesterday saying the case was resolved, and they apologized for the error. They actually apologized to me. I've been fighting this for years, and all it took was a few acceptances. This class has changed my life." And just because there's acceptances there, again, you can't just use the acceptance process outside of equity and expect to see the same level of efficacy. Yes, I mean, there are people that see victory with acceptance. Okay, I'm not saying there aren't. Equity's not the only game in town. But when you wrap your acceptance in the vessel of equity, there is no greater odds of success. I mean, your odds go from like 10% to 100% so long as you commit to it. And there are so many IRS successes that we have had. I can't even count now the number of IRS cases that I've taken on and we've seen discharged. So sometimes they can go back and forth for a little while, especially if the student was arguing with them beforehand. But I have never seen an IRS case fail to be discharged without going to court when the student sticks to it. And that's why I say equity works 100% of the time. It requires that you stick to it, and sometimes it can go on for a little while. And some people don't want to, is it so hard to write a couple of notices every month? I mean, they're not even that long. So, but, if you stick to it, you don't mix it with anything, you're going to see victory. Here's a story of a mortgager. So and this is one of our mentor students. He said he lost his job due to an injury, and was unable to make his mortgage payments. He tried everything he could find, but nothing was stopping the foreclosure. It was only buying time. He was in foreclosure for 2 years by the time he actually found equity. And the man who taught me taught him. And after some rescissions and acceptances, 2 weeks later, he received a letter stating, "Thank you for your payoff funds." So he will get to live in his home for the rest of his life, fully paid off. Now, is that the norm with mortgages? No, it's not usually that easy. I'm just going to tell you right now. Usually you got to go to court for a mortgage. Usually it's a much longer process than that. But we do see these things sometimes solved just with a little bit of paperwork. And a lot of students have been discharging property taxes as well in equity. So, this can really be used for anything. We've seen victories in everything from local county court all the way up to criminal charges in federal district court. Everything from, unsecured debts like credit cards, all the way up to vehicles and mortgages and property taxes that are secured with the house. Now, secured debts are going to be, usually they're not this easy. They're a little more intensive. They require more work. But remedy is available to you completely across the board.
Did everybody else lose the screen?
I think Julian may have cut out. He'll probably reconnect at some point when he realizes that he lost the connection.
Just wanted to make sure it wasn't just me.
Yeah, good call. I was obviously wondering the same thing. Yeah, we'll just give him a chance to restart his connection.
Hey, it looks like I dropped out there.
All right, you're back.
Great. Okay. Sorry about it. How long have we been off?
We lost you for about a minute and a half. I think you may have to reshare your slides as well, because when you drop off, obviously that stops.
Just do the mortgage.
Okay. Did you guys hear the story about the mortgage?
Yes.
Yeah, we heard that one.
Okay, awesome. All right, so let's move on. Sorry about that. So
Still not showing. Okay.
there it goes. So this is a really interesting story about a young man in Chicago. This is also one of our mentors' cases, but so this young man was facing years in prison because you're not allowed to have a gun in Chicago, even though it's like one of the places in the country you most want to have a gun. And so this kid got caught with a gun. And then after he learned equity, he shows up to court. And he begins bringing in equity. Well, it's a packed courtroom. And the judge, of course, needs to make a show. He starts yelling and screaming at him, you sit down and shut up. We'll get to you later. And they just chop through everybody in the court, fines, jail time, probation, whatever, run through everybody in the court until it's just this kid left sitting in the pews. The judge actually gets down off the bench, walks across the court, sits down next to this kid, puts his arm around him, says, I know what you're trying to do. You're trying to bring equity to my court. Just take this gun class and this will all go away. And that's the power in this. I mean, equity makes you equal with the judge. Now that judge, obviously, he didn't care to fight about it that day. I mean, some judges are going to test you, and we teach you how to deal with that. But you'll find that you get much, much better treatment in court when you stick to equity. And the kid really doesn't even have to take the firearm class. I mean, he could discharge that too. But I mean, if you go from facing years in prison and just having to take a class, it's a pretty good deal.
Pretty easy.
So,
I think everyone should take a firearm class.
really interesting story.
Drive,
And here's just some more of our victories. Like I said, we've discharged endless IRS debts. We've discharged IRS debts in the millions, and even IRS debts in the hundreds. We've discharged the wage garnishment. I think I mentioned this. The guy got all the money that was taken from him paid back to him. That was just a few months ago. There was a child custody case where the husband was being sued by the ex-wife, and he wasn't getting to see his kid all that often, and he just started bringing equity to the case. And really, before he even needed a compel remedy from the court, the ex-wife just sensed this change in him, this shift into forgiveness and peace, and they worked it out outside of court. And he credits the equity with helping him do that. He's getting to see his son more often now, and just settle the matter outside of court, which is what everybody should want in that situation. God forbid you would have to be in that situation in the first place. We have compelled hearings, and so we're taking on a federal criminal case right now. Now, as I mentioned, there have been many federal criminal cases that have been discharged in equity. Well, this is one that we have active right now, and we have compelled many hearings in this case, and we even compelled the standby counsel to be removed from the case. So the student had a lawyer before he found us, before he started bringing equity. And the court wasn't letting him turn in anything. We show him how to. First, there's a certain way we put the lawyer in a box, and so that you can actually begin speaking to the court and submitting the court paperwork that they'll actually look at. And then on top of that, we teach you the proper way to fire the lawyer while remaining in honor. And usually then the court wants, if it's a federal court, they want to make the lawyer a standby counsel at the least, which means he's no longer representing you, but he can still come up with ways to get you to recontract with the court, which is obviously not what we want. So even beyond that, we compelled the court to completely get rid of this guy, even as standby counsel. And this case has been going really, really well. We've been working on it for about 8 months now. And we'll give you some updates on how that goes. This is number 5 is the very first case we ever took on, other than, after I learned equity. I mean, we spent a year bringing it to the issues in our lives. Like I said, my wife's credit cards and her IRS debts. But this is the first case we took on for somebody else. It was a woman in New Jersey, and her dogs had gotten out, and the neighbor got mad and called the police, and they found out the dogs weren't registered, and they wanted to vaccinate the dogs and register the dogs. And she was going to court, and she was bringing pre-1933 equity, which is like silver bonds and handwritten letters with a thumbprint, and giving your birth certificate to the court and stuff like that. None of that was working for her. And so she found us. We told her how to unmake those commercial dishonors and how to properly bring equity to the court. And she got the whole case dismissed. So very first case we took on for somebody was a win, and her dogs remain unvaccinated to this day. Sometimes when people come to us, like post sentencing, like when I gotta be in jail in 10 days. They want me to show up for jail in 10 days. Well, that's really not enough time for us to teach somebody the process in 10 days. I mean, it's a graduate level process. But this was right around the holidays, and we were able to buy this person an extra month of time with their family instead of having to go to jail right before Christmas. They got an extra month, and then the amount of time that they were sentenced actually was very much reduced. So, sometimes that's the best you can do for somebody. If you only have 10 days, that's still pretty awesome. We discharged some serious criminal contempt charges in another child custody case. We have a very particular way that we deal with contempt charges. Lots of credit cards that we've discharged, other unsecured loans, unrelated to credit cards. I mean, just loans that people have taken out. SBA loans, we've discharged many of those. Student loans, I mean, you name it. Any kind of unsecured debt, much easier to bring equity to than a secured debt. And I can't even count the number of times and the amount of money that we've discharged with that. We can get attorneys removed from cases. We can also get judges removed from cases. I mean, there's an equity student I know that's on his 10th judge at the moment. And they only have 13 judges in that jurisdiction, so they're going to have to do something soon. I mean, the case has been going on for a long time because he brought a lot of other Patriot processes before he started bringing equity, so there's a big mess to clean up. But once he got into equity, he has gotten 9 judges to recuse themselves on that case. It's pretty amazing. And we've gotten an arrest warrant discharge. We're working on a couple more warrants right now, and all of that is just in our first year of teaching. So, just a lot of amazing victories. And then our mentor, he's been teaching equity for 10 years. He has about 30 years in the Patriot movement overall, but he's been teaching equity for about 10 years, and just amazing amount of victories. Tons of mortgages, property tax discharged. Like I said, federal criminal cases. I mean, you name it. There's no more comprehensive or effective remedy than equity. So just imagine never having to worry about going to the mailbox, about getting a knock at the door, about seeing lights in your rearview mirror, or receiving a call from a debt collector or a tax agency, or really being challenged about anything. And that is what equity is all about. And this is an advanced course that will teach you everything you need to know about being untouchable as a defendant and being left the heck alone. Well, how much is that worth to you? Just do the math. We're going to have 13 live class sessions. They'll be on Wednesday evenings at 6 p.m. Central. If you have to miss a class for any reason, all the classes are recorded. You're going to have permanent access to those recordings. We like to keep the class groups to small groups, 20 students at the most. If people have really serious issues that they're dealing with, I'll still let them in the class. But we like to keep it to a small group. And between me and my mentor, and a couple of other of his students that are teaching now, we have thousands of victories, and there are lifetime benefits. I make the guarantee to all of my students, I will stand by this for my entire life. I'm here for the rest of my natural life to answer any questions that you might have about equity. And of course, there's also the alumni group. You have permanent access to the recordings. So there are just several amazing lifetime benefits. This is a lifelong process that you can pass down to your children. So you can contact me on Telegram at @vitiate0. That's how you spell it there. That's a 0 at the end. And you can also right click on my name in this video chat and click on send message, and that way you can if you got on late, make sure you do that. Make sure you get with me on Telegram. I'll get you the full class information, and get you signed up if you're interested. And then David said he's recording this, so I believe that he'll be making that recording available to you as well. So there we have it. I would love to take questions now if anybody has any.
All right. So just before people jump in, we don't have on Telegram that beautiful raise your hand feature like in Zoom. So we're just going to have to take it at pace. So if someone wants to ask a question, now if someone would rather ask a question without speaking up, you can just write it in the Telegram chat under equity, under the equity topic. And I will take a look at that, Julian. You can also take a look at that topic if somebody writes their question. But if you do want to go ahead and ask your question directly,
Hi, Julian.
Hi, Julian.
You had
Hey.
said if something was seized that you can get remedy, but you said equity, you ideally want to be the defendant. So can you explain that a little?
Yeah, so if somebody brought in
Okay, how do you, like, in my case, it was the bank that I was never late on mortgage payments and they still put my house into foreclosure. I ended up paying off the note to get it out of foreclosure. So there was no case, um, and it's been paid off for a few years now. How would you go about that? I was never a defendant.
so you still have the house?
Yeah.
Yeah, so I mean, technically that money wasn't seized from you. They just kind of put you in an impossible situation where you had to pay it all, but you were the one who paid it. So I don't think the redemption process would really apply there. It's more if something was taken from you. It's not fair of them to make you have to pay it all up front like that. I mean, but the redemption process is more for when things are taken from you, against your will.
If you voluntarily give.
So
If you voluntarily give the money, then it doesn't really apply.
Okay, so I actually should have let it go to foreclosure and stuff, huh?
Well, I mean, it can be pretty stressful trying to bring equity to a foreclosure. I mean, especially if you're in a non-judicial state, you get very few chances before the judge. And it sounds like this was a while ago anyway. So, to me, it sounds like you did the right thing, but,
Okay, thank you.